Today we're going to dive into a really fascinating legal battle. It's a story that starts with something so simple, the desire for a perfect smile. But it ends up in a courtroom forcing judges to ask a huge question about what we're actually buying when we pay for a professional's work.
It really gets to the heart of our rights as consumers, right? So let's see how this all played out in the very real case of a woman named Brenda Golden versus the Denmat Corporation. All right, so our story kicks off back in late 2004. We meet Brenda Golden, and all she wants is to replace her old dental veneers to finally get that super white smile she's been dreaming of. And one day, she finds what looks like the perfect answer. She's flipping through a magazine and sees an ad for something called ceramic veneers, which are made by a company called Denmat. The ad was so compelling, she actually picked up the phone to learn more.
So Denmat sends Brenda their brochure, and this is where it gets really interesting. It was just filled with these incredibly powerful specific claims. It talked about long-term research showing the veneers would last up to 16 years with, and I'm quoting here, no discoloration and 100% retention. I mean, these weren't just vague marketing buzzwords, they were specific, measurable promises.
So, totally convinced by these promises, Brenda gets in touch with a Denmat authorized dentist, a Dr. Gill, and pays nearly $10,000 for the whole shebang, the veneers themselves and the procedure to put them on. But that dream of a perfect smile, it started to fall apart almost immediately. The problem started right away. When the veneers were put on in January 2005, one of them already looked cracked. Just 3 weeks later, one came loose. 6 months after that, another one came off. And by March of 2007, a third veneer had just fallen right off. And then came the real kicker. Brenda writes to her dentist that the veneers, the very same ones that were promised to have no discoloration, had developed a gray cast. That brilliant, white smile she paid for was literally fading away. So of course, Brenda sues, and this brings us to the absolute core of this case. It's a question that sounds simple, but trust me, it has massive implications for every single one of us.
So what did Brenda actually buy? Was she buying a thing, a physical product, the veneers? Or was she buying a professional service, the skill of the dentist applying them? Now the answer here is everything, because totally different laws, with very different levels of consumer protection, apply depending on whether it's a good or a service.
To figure this out, courts have this tool called the predominant purpose test. It's for these kinds of mixed transactions. The test just asks, what was the main reason for the purchase? The main event. If a court decides the product was the main event, then these super powerful warranty laws from something called the Uniform Commercial Code, or UCC, suddenly kick in.
The court used some brilliant examples to explain this. They said, look, filling a cavity is obviously a service. You're trusting the dentist's skill, not the specific goo they use for the filling. Same thing for braces. You're buying the orthodontist's whole process. But Brenda's case was different. She specifically went looking for the Ceramate brand veneers before she even had a dentist. That made the whole thing really murky. So murky, in fact, the court said, you know what? This is a question for a jury to decide.
Okay, so if a jury decides this was mainly about a product, then a whole bunch of really powerful consumer protections called warranties come into play. Let's just quickly break down the three main types that were at the center of this whole case. First up, we have the express warranty. This is a direct, specific promise a seller makes that basically becomes part of the bargain. So think back to that Denmat brochure promising no discoloration for up to 16 years. The court said a jury could totally decide that wasn't just marketing fluff, it was a legally binding promise. Second is something called the implied warranty of merchantability. This is basically an unwritten, automatic guarantee that a product is fit for its ordinary purpose. It's the reason you expect a chair to hold your weight, right? Or a raincoat to actually keep you dry. In this case, you'd expect dental veneers to have some reasonable durability and, not start falling off in a matter of weeks. And finally, we have the most specific guarantee of all, the implied warranty of fitness for a particular purpose. This one is created when you, the buyer, have a unique need, you tell the seller about it, and you rely on their expertise to get you the right thing. Remember, Brenda didn't just want veneers. She told Dr. Gill she wanted super white teeth. That very specific request was her particular purpose. The court used a fantastic analogy to explain this. Imagine you walk into a shoe store and you tell the clerk, hey, I need shoes for climbing a mountain.
By relying on that clerk's judgment to pick out a pair for you, you've just created an implied warranty that those shoes will be suitable for that specific, really demanding task. If they fall apart on the trail, well, that warranty's been broken.
So after all this, who won? Well, it's not that simple. The appeals court didn't actually declare a winner. Instead, they made a critical decision that completely changed how this case would move forward. You see, the lower court had actually thrown Brenda's case out completely, but the appeals court stepped in and reversed that decision. They said, whoa, hold on, this is not some open and shut case. They ruled the facts were just way too complicated for a single judge to decide alone, and that Brenda absolutely deserved her day in court.
So what they did was send the case back down to be decided by a jury, and they laid out the exact questions that jury would have to answer. Was it a good or a service? Were these express and implied warranties actually created? And, the big one, were any of those warranties broken by veneers that cracked, fell off, and turned gray?
Now, you might be thinking, okay, this is a pretty interesting story about dental work, but why does this really matter to me? Well, believe it or not, the ideas at the heart of Brenda Golden's fight are relevant to almost every major purchase you'll ever make.
This case leaves us with 4 really powerful lessons. First, ads and brochures aren't just talk. Their specific promises can become legally binding warranties. Second, you have a right to expect a basic level of quality from the things you buy. Third, that blurry line between a good and a service is incredibly important because it decides what your rights are. And finally, when you tell a seller exactly what you need something to do, you can create some serious legal protection for yourself.
So the next time you see an ad that makes some huge promise, or you tell a salesperson exactly what you're looking for, just remember Brenda Golden's fight for her super white smile. It might just make you think a little differently about the promises businesses make and what those promises are really worth.